When someone dies in Florida, families are left navigating two parallel realities. There is the immediate grief of the loss, and then, right on the living room table, there is the sudden reality of the paperwork. Practical roadblocks appear almost instantly. You might discover that the bank will not permit access to a checking account to pay for the funeral. Vehicle titles remain untransferable, and there is a looming uncertainty about what happens next with the family home. Accessing and legally transferring these assets requires a mandatory checkpoint known as probate. Probate is the court-supervised process of identifying a deceased person's property, paying their final debts, and officially moving those assets to the rightful heirs. Families are often surprised to discover that even a modest estate, perhaps just a checking account and a used car, requires a formal court order. Without these documents, financial institutions will refuse to move those funds. Florida is currently preparing to change how this system handles those smaller estates. Beginning July 1, 2026, the state is expanding a specific legal path designed to bypass the most time-consuming parts of this process. Understanding this upcoming legislative shift can mean the difference between a prolonged, confusing legal hurdle and an efficient resolution for the family. The simplified path for smaller estates is called summary administration. It involves less paperwork and a significantly shorter wait for a judge's signature than a full formal probate. This chart shows the historical bottleneck for this process. Under the previous rules, an estate generally had to be valued at $75,000 or less to qualify. If the assets were worth a single dollar over that limit, middle-class families were pushed into the slower, more expensive formal probate system. Effective July 1, 2026, the Florida legislature is doubling that qualification threshold to $150,000. This shift directly affects how the state handles common estate assets. A family dealing with a car, an $80,000 bank account, and a modest investment fund would previously fail to meet the standard. Now, those same assets fall within the boundary for the faster process. However, a faster track is still a track through the court system. Summary administration requires precise legal filings and strict compliance. It speeds up the court's involvement, but it does not remove it. The only way to completely avoid probate is through proactive, pre-death estate planning. Strategies like setting up a revocable living trust or carefully updating account beneficiaries transfer ownership outside the court's view. Once someone passes away, the question is no longer how to avoid probate, but which legal process applies. The new $150,000 limit ensures that when average families arrive at that question, significantly more of them will be eligible for a timely legal resolution. That new limit immediately raises a practical question. If the threshold is $150,000, what happens if the deceased owned a house? Real estate values alone would push almost every estate over the line. Florida law gives unique constitutional protection to a primary residence, known as homestead property. Because of this special status, the value of the family home often bypasses the standard estate calculation entirely. It is generally not counted toward the $150,000 limit for summary administration.
But there is a danger in assuming the house requires no paperwork at all. Families often think the property simply passes to the heirs automatically. In reality, a judge must still issue a specific order confirming the transfer. Even though the home's value might not count against the limit, the family still needs that order. Without it, title companies will not allow the heirs to sell or refinance the property, because the legal chain of ownership remains unconfirmed. Owning a home will not necessarily disqualify an estate from the streamlined $150,000 process, but it demands precise, separate legal action to secure the property rights. Because the new law does not take effect until mid-2026, families managing estates valued between $75,000 and $150,000 face a distinct timing calculation. Should you delay filing your probate case to take advantage of the upcoming expansion? Pausing the legal process carries heavy risks. If there is a pending real estate sale, waiting could kill the deal. Unpaid creditors may initiate their own actions against the estate, and unattended bank accounts can eventually be seized by the state. On the other hand, if an estate is highly stable, perhaps sitting at $90,000 in a secure account with no urgent debts or family friction, waiting for the July 2026 effective date could theoretically save the time and expense of formal administration. Deciding when to file is a strategic legal calculation. It requires balancing immediate financial vulnerabilities against the procedural benefits of the future law. It is also crucial to recognize that falling under the $150,000 threshold does not automatically mean summary administration is the right choice. Certain facts immediately disqualify an estate from the faster track. If surviving heirs are actively disputing who gets what, or if someone is formally challenging the validity of the deceased's will, the simplified process is no longer an option. The same holds true for unknown variables. If the family suspects there are hidden assets, if there are missing heirs, or if there are complicated creditor claims that need to be negotiated, summary administration lacks the legal mechanisms to resolve those issues. In those scenarios, formal administration is strictly required. The court must appoint a personal representative, granting them the legal authority to gather information, communicate with institutions, and settle disputes on behalf of the estate. An estate's total dollar value dictates basic eligibility, but the family's unique dynamics and the complexity of the assets dictate the actual legal path required. Florida's 2026 legislation provides a useful tool to streamline probate for modest estates. To utilize it correctly, families must evaluate their situation asset by asset, checking titles, beneficiary designations, and potential debts. Navigating this transition should not be based on guesswork. Mapping out the correct legal process requires the insight of a qualified Florida probate attorney who can review the facts and identify the most efficient route forward. Navigating the aftermath of a loss is never easy, but with the right legal roadmap and professional guidance, finding clarity and protecting your loved one's legacy is entirely within reach.